conspiracy that would tie those acts together. The second part, I don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature. So I'm not going to spend a lot of time on that. I don't want to take up the court's time. I have some things in my written motion. Third, a pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other. And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury, and that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they've stated, I would say universally, I mean, it's been a year, so I don't know that I have everything in my head, but I believe they've stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas. Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffery Williams' house on May 9th, 2022. Each of those counts is either specifically gun or a gun count or a drug count, or they're predicated on a gun count or a drug count. There has been zero evidence of Mr. Kendrick in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession. And I'm assuming they're going to argue this because they have two pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. So, but let's assume he's inside the house, even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. Zero on intent and zero on his ability to access those weapons and drugs. Last, Your Honor, with respect to count 63 is the 133 charge against Mr. Kendrick. As we discussed previously in court, there's an essential element of 133 that has been left out. So I believe a directed verdict on 133 would be, on that count would be appropriate.
Let me interject and ask you, I saw that Mr. Abadi had sent something that addressed whether, even if directed verdict is appropriate on that, a lesser included. Can you address that?
Sure. I saw the one specific case that I saw that would support Mr. Abadi's position was Martinez v. State, 318 Georgia Appeals 254. And that case, from the limited time I had to review it and do further research, does appear to support Mr. Abadi's position regarding 131 being chargeable. But that case, I cannot find a single other case that follows that case. I also, just again, to be candid with the court, I don't see any case that says that case is wrong. But I would argue that the 131 count should not be charged to the jury, if for no other reason than the state puts that 133 charge. Well, I don't know what the state's motives are, but I would argue that the motives of charging 133 versus 131 is that 133 carries significantly higher penalties, and that they put in 133 in order to have greater leverage in plea negotiations. And I don't think, after having used that leverage for the past 2 years, that they should now that they can't prove up the 133, should be allowed to reduce it to the 131. But I cannot argue right now before you that Martinez does not support the state's position, Your Honor. And then again, I'm going to adopt whatever arguments that Mr. Shart is about to make on behalf of his client that would also apply to Mr. Kendrick.
Okay. So, Mr. Shart, I mean, I guess the overlap, there's overlap on counts 1 and 2 for these two defendants, but those are the only counts that overlap, right? Yes.
Yeah, I believe that's
Okay.
right.
All right.
Do you have any further questions for me, Your Honor?
No, not right now. Thank you, Mr.
All right, thank you, Your Honor. I'd be happy to answer any other questions you have.
Appreciate it.
Good morning, Your Honor.
Morning.
Okay. So I have arguments regarding several different counts in this indictment, as well as some of the overt acts, which I believe also need to be addressed, the alleged overt acts. And there's different arguments for different counts and alleged overt acts. I'm going to start with dealing with the this argument applies to the RICO count.
Can I ask you something
Yep.
before you get
Yes.
started that might assist me? I think Mr. Weinstein said you might have a chart. Do you have something that's shareable with the court, or
I
is it?
don't. I don't. A chart is overstating what it is.
Okay.
We went through. We were trying to determine what specific counts, what
Okay.
evidence has been provided to the jurors so far in this trial.
Okay.
So let me just give a little background. I'm going to ask the court to consider Ruan v. United States, RUAN v. United States, 142 Supreme Court 2370 to 2022 case. That case explained that the commonly understood rule that as a general matter, our criminal law seeks to punish vicious will. Consequently, when courts interpret criminal statutes, courts start with a long-standing presumption traceable to common law that the legislature intended to require the criminally accused possess a culpable mind state. Applying the presumption of scienter, courts have been legally mandated to graft the material elements of mens rea into criminal statutes that are silent on the required mind state. Okay, and to bring it to this situation, the RICO statute is silent as to mens rea for the accused, as is, well, and not so much mens rea. Well, it is mens rea, but there's also an aspect of this that will apply to the gang statute as well. In United States v. Resendez-Ponce, 549 U.S. 102, it's 2007 case, the United States Supreme Court wrote that the elementary legal principle is that every count of an indictment must set forth all material elements of the crime charged in order to be valid. In Division 2B of Elonis, ELONIS v. United States, 575 U.S. 723, it's 2015 case, our highest court again taught that the fact that if a statute does not specify any required mental state, it does not mean that none exists. The Elonis court explained that courts have repeatedly held that the mere omission from a criminal statute of any mental or criminal intent should not be read as to dispense with this essential element. The rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. In other words, just because there's no mens rea listed in the criminal statute does not make it a strict liability crime. Okay, going to the indictment in this case. count 1, RICO. Mr. Stillwell and Mr. Kendrick to be guilty of count 1, the jury under the law would have to find that Mr. Kendrick and or Mr. Stillwell joined the conspiracy knowingly and willingly. The state, I'm going to ask Your Honor to consider the Cotman case, C-O-T-M-A-N v. State, 342 Georgia Appeals 569. It was a conspiracy to commit RICO case. That indictment alleged knowingly and willingly. My understanding, I have not seen the indictment, but I've been told the Trump indictment also includes knowingly and willingly. In this case, the state has not alleged, and the grand jury did not return a indictment, a true bill, alleging knowingly and willingly. The indictment for count 1 is missing an essential element that has been required by the case law. Although OCGA 1614-4 fails to include knowingly and willful mens rea requirement as discussed above, when the statute is silent on mens rea, courts define the proper mens rea requirement to avoid it becoming a strict liability crime. I will point the case to Wetzel, or I think it's Weitzel, v. State, 298 Georgia 20, that discusses the concept of just putting unlawful. Does unlawful, as the state did here, does that cover knowingly and willingly? Is that an effective substitute? Our position is it is not. We believe that the Weitzel case supports that. So, Your Honor, we believe that the RICO count 1 is missing an essential element that has not been required by statute, but is required by the case law. And because that knowingly and willfully requirement, that mens rea requirement is missing from the indictment, count 1 is subject to a directed verdict, a general demurrer and directed verdict as it applies to both Mr. Stillwell and Mr. Kendrick. Now, turning to the gang counts, and I can get you the specific counts when I have a moment to look at the indictment. But going to the gang counts, the requirement, again, the gang statute under the Georgia Code is absent as to an essential element of the crime, which is in furtherance of the gang. That statute was in constitutional jeopardy before the Rodriguez case. The Rodriguez case saved the statute by adding an essential element to the gang statute, which is not only someone associated with the gang committing one of the specified crimes under the Gang Act, and the existence of a gang of 3 or more people, but additionally, Your Honor, they added to save the statute constitutionally, the Rodriguez court added the requirement that the alleged illegal act must be in furtherance of the gang. The indictment in this case for all of the Gang Act violations, all the alleged Gang Act violations, none of those alleged Gang Act violations on this indictment returned by the grand jury allege that the act committed was in furtherance of the gang. Now, we know that that must be proven. The jury charges that we're going to give the jury list in furtherance of the gang as an essential element of this crime. And it is absent in all of the Gang Act violations alleged in this indictment, as the indictment for those counts does not allege every essential element of the crime. Those counts are subject to a general demur and a directed verdict as well. So that's one aspect of my arguments. I can move on to my other arguments, or I can put a pin
Give
in
me
it.
just a second.
And Mr. Abate just gave me, just helped me out, and I appreciate that, Mr. Abate. I'm referring to count 57 for Mr.
50,
Kendrick, and
51,
50 and 51.
57.
Yeah.
Thank you. Okay, go ahead.
So moving on to the overt acts, and I adopt Mr. Weinstein's arguments regarding count 2 as well. Moving on to the alleged
Well,
overt acts.
Can you actually, I mean, you can adopt those, but do you have anything to add with regard to count 2? Because Mr. Weinstein was basically talking about, you know, the evidence or lack of evidence as to his client specifically.
The only evidence against Mr. Stillwell, there's no cell phone evidence. There's nothing of that nature. There's no identifications from the scene. The only evidence are social media posts and the testimony of, well, not the testimony, the out-of-court statements by 2 individuals, one being Quindarius Zachary, who completely disowned what he said, and back in the interviews when he was under the pressure of incarceration, under the pressure of prosecution, and we pointed out, hopefully effectively, that Mr. Zachary's story about this confession changed in material ways from when he told the story in 2015 to when he told the story in 2017. When this confession allegedly occurred changed, what was said allegedly changed, the circumstances changed, and then Mr. Copeland, I mean, you were here for that. He made out-of-court statements under the pressure of incarceration. He's openly admitted he would have said anything to get out of jail, to avoid prosecution, to avoid Rice Street, and his statements were not even that he witnessed anything, but he was told something by someone else who did not testify. So that is as far as I can tell, the entire university evidence against Mr. Stillwell, and our argument is that it doesn't clear that hurdle of surviving directed verdict.
All right.
So moving on to the alleged overt acts, and I'll point out in this indictment, it lists, this is a conspiracy to commit RICO. So they don't need to prove the predicate acts. They don't, those 2 related events within 4 years, they don't need to prove that, because all they need to prove is a conspiracy and 1 overt act. So,
Well, a conspiracy to commit 2 interrelated racketeering acts in furtherance of the enterprise.
yes, okay, that is fair, but they don't have to prove that the
That they
acts
occurred.
actually occurred.
Agreed.
So on page 14 of their indictment, it starts part 3, acts in furtherance of a conspiracy. It says, in furtherance of the conspiracy and to effect its objectives and purposes, the defendants committed and caused to be committed among others, the following overt acts, certain of which constitute acts of racketeering activity. So this part 3, this isn't about, they identify some things as overt acts. They identify everything as an overt act, but they also identify certain things as falling as a predicate under 1614.3 for racketeering activity.
Mhm.
The nature of this allegation is it's a conspiracy. So they don't have to prove that these predicates occurred. So essentially, my reading and my argument is that part 3 is essentially a list of overt acts. That's what it is.
Yeah.
And we are all of the same opinion. We're giving the jurors a jury instruction. It's clear, it's in the statute that the statute of limitations for the overt acts is 5 years before the date of indictment. And that's going to be, my understanding, that's going to be charged to the jury. So I, as a general principle, I do not understand if they only need one overt act, okay? And that overt act has to be within 5 years of the date of indictment. All of these other alleged overt acts that can't count, can't be used, and are completely not needed. I could see a situation, for instance, if they needed to show 2 overt acts, and one had to be within 5 years of the indictment, but one didn't, okay? It was just the last one needed to be within 5 years, but they needed to show 2. I could see the need for all of these other allegations, but that's not the case. They need to prove 1, according to their arguments, and it has to be within 5 years of the indictment. So everything that predates that cutoff date, which I think would be May 10th of 2017, it can't be used to convict.
It's not sufficient.
Well, but it doesn't add anything either because you only need 1.
Well, they
So-
also have to prove a conspiracy and an enterprise. And so,
They do have to prove a conspiracy and enterprise, and I'm not arguing that they can't argue about these things in closing. I'm not, I never argued that they couldn't get into these things, but they shouldn't be alleged in the indictment going back to the jury because we're telling the jury, we're sending the jury a completely mixed message. We're saying you can't find an overt act that
we're not
would-
saying that. We're not saying you can't find an overt act before the 5 years. What I will be saying is it is necessary if you want to convict
right.
that you find, or if you believe there is evidence sufficient to convict, part of that evidence has to be an overt act within 5 years.
But by definition, no, I'm not, believe me, I'm going to fight tooth and nail about any duty to convict language, and I don't think there is any. But in layman's terms, if they find an overt act within 5 years, that is legally sufficient
Correct.
to authorize a conviction, which would make all of these other.
I hear what both of y'all are saying on that, and I just don't think I'm convinced that it should not even be presented to the jury because it's not sufficient in and of itself. But go ahead.
Okay, and
I mean, that's not exactly directed verdict issue anyway.
no, but I believe it is. I would say at this point, it is mere,
Surplusage.
yeah, mere surplusage, I would say, and that it's going to confuse the jury to have this list of alleged overt acts where legally none of these prior to May 10, 2017 can be used to authorize a conviction on the overt acts, for the overact element of the RICO conspiracy.
Mm.
So, and then, additionally, Your Honor, in all candor, you know, we stayed after court. We went through all the charged offenses in the indictment, all of the alleged overt acts in the indictment, and we did our best. We didn't have the evidence in front of us. We did our best over the night, you know, over the evening and this morning to go through those, and we either said we're not challenging it. We recall that there was evidence that would survive a directed verdict.
Mhm.
We were unsure, or we're pretty certain there was no evidence of this.
Okay.
And so, but you know, it's a long list, and probably I would suggest to Your Honor, for that part of this argument, it kind of be more of a back and forth as opposed to me just listing off a bunch of numbers. I can.
Well, I've got to know what you're alleging.
Okay.
Are you talking about, like, help me out, which overt acts you think there is no evidence presented for?
Yes.
Okay.
As well as predicate acts.
What's that?
As well as predicate acts.
Yeah, but they're,
Yeah, okay. You have the list?
Have y'all talked to the state about this at all yet?
we haven't had an opportunity.
Does the state acknowledge that there are maybe at least some overt acts that no evidence was presented on?
Yes, Your Honor, and
Okay.
we don't intend to have that go back to the jury, and so we can discuss
right.
with defense
All right,
counsel.
I
those
can
acts.
certainly let y'all do that, and if there's some that, I mean, I know there were at least a few that no evidence got presented on. So to the extent y'all can reach agreement, that would be fine, and then if we want to take it up later in the afternoon after y'all have gotten a chance to get together on it, that'll work.
Okay, thank you. Your Honor.
And there may be some y'all want to argue about, so we can do that later. So that's fine.
Okay.
Okay, and then do you want to argue specifically as to the other counts against Mr. Stillwell?
Well-
We've done kind of 1 and 2 at this point.
Right. I've argued the gang counts.
Oh, right, and yeah,
And I've argued the RICO. The Shamal Drinks alleged murder. I
mhm.
think the video speaks for itself. I don't believe that there's sufficient evidence that would authorize a rational juror to come back with a guilty verdict. You know, we heard from Dr. Stanley, the ME. She was clear. Mr. Abate asked if someone's foot could stay on the brake, and she acknowledged that a foot could come on the brake and stay on the brake after being shot in the neck. And I asked, what about lifting the foot off the brake and putting it back down? And she said that would be an impossibility. We see clear from the video that Mr. Stillwell was, I think, gone. I'd have to review my notes, but I'm going to say it was about 26 seconds, I believe, between when his car left and when that brake light on Mr. Drinks' car was going on and off. Additionally, we have the U-turn. Additionally, we have the negative gunshot residue test, that we have no muzzle flash.
Mhm.
It seems to me that we would have a muzzle flash. If we don't have a muzzle flash, the logical conclusion would be the shot was fired from inside the car. We have a negative gunshot residue result. And we heard from Mr. Coven from GBI. He followed all the procedures. although there's been speculation and of course the grave suspicion jury instruction that we all go by, we're not supposed to speculate. We're not supposed to use conjecture, I think is the word that they use. And there's just a lot of speculation. Well, what if this happened? What if he cleaned the car? And there's no evidence that supports any of those theories. So the Drinks murder, as well as the associated charges with the Drinks murder, which would include a gun charge and also a gang charge, I believe, would also be subject to a directed verdict. As it applies to the final gun charge of Mr. Stillwell's on the 17th, I'm not going to argue that there's not evidence that could survive a directed verdict. You know, we've heard it was the gun that was found on Meadowlark was registered to Taisha Alexander. We've heard Taisha Alexander is Mr. Stillwell's girlfriend at the time. But I will adopt Mr. Weinstein's arguments. This was indicted as 16-11-133. We were put on notice for 133. It's missing an essential element. And we're going to argue that the state should not be able to alter on the eve of closing arguments, alter the charges. And also, I'm not even sure about the mechanics of how that would happen at this point. It's charged under a certain statute in the indictment. I guess
Well,
if
I
it were
think it would be just like we always do any kind of lesser included offense. I mean, that's their argument is, yeah, we may not have the elements, and they certainly don't have the elements for 133, but we have the elements for 131, and that's what should get charged instead.
Okay, well, Your Honor, every time that I've dealt with lesser included, it's because there's some sort of, maybe not surprise, but the evidence didn't come across quite as we were expecting or the state was hoping, or the defense requests a lesser included. We're not requesting a lesser included, first of all, but they put us on notice to defend against 133, and they left out an essential element, and now we're changing the charges on the eve of closing arguments. So that's my argument regarding that.
Your Honor, to aid in argument for the court, I'm going to be addressing the demur regarding count 1 RICO. And if the court has further questions on the lesser included of the 131, Mr. Abadi's going to address that. Mr. Floyd, if the court regarding the Rodriguez case, which was a case he handled on the demur on the street gang, if the court has more questions on that, and then Ms. Hilton would handle the remaining counts other than count 1. I just wanted to give the court that overview.
Thank you.
As the court's aware, Your Honor, the charge as alleged, the conspiracy, the state believes that there has been ample evidence that a rational juror could find that they conspired to commit at least a pattern of racketeering activity. And obviously, defense counsel has focused on the money or proceeds. The state believes that for purposes of directed verdict, the easier one to start with is, which is count 12 of the indictment, and the 3 criminal objectives as the court outlined in our proposed
12.
page 12 of the indictment, Your Honor.
All right.
That focus on murder, aggravated assault, acts of violence, as well as intimidation of law enforcement and witnesses, which is, I give them numbers in terms of the order of the bullet points. I believe that that's the easier argument or more efficient, because there's
Right. I mean, if the state has alleged 2 different ways of the defendants having violated RICO through a RICO conspiracy, and y'all only have to prove one, you don't have to prove both.
Correct,
So
Your Honor.
you're saying there's at least evidence as to the overall purposes, Part B of RICO.
Correct, Your Honor. And a couple things is in terms of that objective of racketeering activity, specifically the murder and the aggravated assaults. You have from the defendant's own words their and tattoos, their allegiance to YSL. I don't want to cite a litany of cases, but there's a number of factors that courts use to establish an enterprise. For example, United States v. Harris, 695 F 3rd 1125 1136 is a 10th Circuit 2012 case, is display of colors. Jewelry, clothing, all of those are just 3 to start. You also have tattoos, which are permanent. And so Mr. Kendricks has slat on his left forearm and a large snake that was introduced, I believe yesterday or day before, on his stomach that goes up to his neck. You have defendant Stillwell, who has multiple admitted exhibits and posts that reference slime or reference his, for example, exhibit 430 VV is defendant Kendrick overt act 133 with a red bandana and a YSL pendant. State's exhibit 511 VV as admitted is overt act 138 is defendant Kendrick with a hat with a rat crossed out on it. State's exhibit 38 November is overt act 134 where you have Kendrick pointing at the cameraman, 2 individuals with Make America Slime Again. And I could go on, but the point being you have both 2015 exhibits where Detective Gaither and Detective Dennis, you had Twitters of Mr. Sledge, you had Twitters of Mr. Zachary, Twitters of defendant Stillwell, where multiple, and I'll give a few examples that actively and openly possess my slimes, YSL, this is my brew. And that allegiance coupled with the evidence at trial of the murder of Donovan Thomas to begin with, which is captures overt acts 16 through 20, which the evidence of that murder from the interview statement of Kenneth Copeland on June 10th, 2015, and Quindarius Zachary on August 15th, 2015. Quindarius Zachary's interview, which was played for the jury and is in evidence, states that defendant Kendrick and Stillwell confessed to him that very night. And defendant Williams Condo, who rented the Hertz rental vehicle that the Infinity rep, Mr. Thomas Burnett, stated from watching the surveillance video, which I believe is 296 Yankee, that Detective Teague with APD introduced, that was an Infinity Q50. All of those things combined, that statement of Copeland and Zachary for the why it is a criminal enterprise murder. There's no personal disagreement between Mr. Thomas, Mr. Kendrick, Mr. Stillwell. It is that rivalry of a criminal street gang that weaves through this case. And so in terms of commonalities, it is similar offenses, whether it's victims, the method and mode of operating. In this case specifically, you have a number of incidents that involve multiple YSL self-identified or APD gang detective identified members committing acts of violence together. In Donovan Thomas, you have 4. In Shamel Drinks, you have 4, at least defendant Stillwell, Mr. Garlington in the white Audi, defendant Nichols and Miles Farley in the white Ford Fusion. On the April 28th, 2015, which was Demekion Garlington getting jumped at Club Crucial, there's a 911 call around 2:00 a.m. Fast forward, you have 2 shootings at 1903 Drew Drive and 1428 Adele. You had testimony from Ms. Bell, whose home was shot, crime scene technicians and responding officers. And you had in the interview and testimony of Zachary and Sledge, that act in concert, which was only 3 months after the murder of Donovan Thomas, shooting at, intending to strike rival opposition members, the ABG, Inglewood family, YFN, that group. So from January 10th, 2015 to March 14th, 2022, of the murder of Shamel Drinks, the targeted acts of violence in concert by YSL members is towards the same opposition group. And that's significant for multiple reasons, because as the court knows in RICO, evidence can have multiple relevant purposes to both prove the criminal enterprise and also prove the pattern of racketeering. And I think what is important in this case is, although the state did not allege subsection alpha or bravo of the RICO statute, actual commission of racketeering activity gives clarity that this conspiracy was not some fanciful idea. It was actually alive and well. The best evidence of a conspiracy in a group is a decade's worth of similar victims, methods of operating, and public and active allegiance to this YSL enterprise afterwards, that this case and the evidence through testimony and exhibits has established. So the courts, or the state, as a number of other factors, and I will not rattle off all of these cases that are other factors the court looks to an enterprise, gang and hand signs. There's been evidence admitted in testimony from APD gang detectives of the quintessential YSL hand sign, the wiping of the nose, greeting phrases the court has heard and seen in text messages and wiretaps, slat and slime.
Why don't you move on beyond
Yes.
enterprise to some of the other necessary elements?
Yes, Your Honor. So does the court have a specific necessary element that the court would like to hear?
Well, what were you going to talk about next?
Fair enough, Your Honor. So to give structure, moving on from the enterprise, when in terms of agreement or the defendants agreeing to be a part of this, the state's argument, and again, the evidence can have multiple relevant purposes, the tattoos and the public, both association with YSL members and active promotion through either of that criminal street gang through their own words or social media of showing allegiance to that, posting with YSL pennants, using the common gang identifiers and hand signs and with other YSL members throughout from 2015 to as recently as 2022 shows, and the commission of the racketeering activity shows that they were a part of it. As in, you do not need, of course, a written contract. You do not need, of course, some videotaped roundtable of discussion. Their actions speak louder than words. And so if you need to, there's ample evidence a rational juror could find that because of the commission of murder, aggravated assault, and continued association, that they have actively agreed to be a part of this enterprise through their very own actions. You also have October 1st, 2015, where Martinez Arnold gets jumped at Magic City by Kelvin Watts, Shell Kel, who of course has been talked about this week in relation to March of 2022, which shows a commonality. And then he calls Mr. Kendrick, who rides with him, where they get stopped with the multiple firearms in the Trestle Tree area, which there's been testimony from Detective Griffin, who was the lead detective on the Tierra Jones homicide. There's been detectives from multiple APD gang detectives about where Summerhill or ABG in that area is where their territory, so to speak. So that action, the January 10th, 2015 murder of Donovan Thomas, however many months later you get to October 1st alone, shows a commitment and an agreement by your very actions, willing to either assist or actively participate in racketeering activity. Furthermore, Your Honor, of course, I think the easiest of this, one overt act committed, and of course, one committed within 5 years of the indictment. The state has, I will use because it's, I believe, one of the most readily assailant overt acts is the murder of Shamel Drinks, which the state believes through the testimony of Viverito, the social media introduced, is a rational juror of fact would find that to be street gang related, enterprise related. Again, there is no evidence of anything other than association with a rival gang that is in evidence of why Shamel Drinks would be murdered for going to pump up his car with gas. And so that act is certainly, it's only a few months before the indictment itself. That alone, the state believes there's been ample evidence that defendant Stillwell has committed that act along with other YSL members, and that alone, a rational juror could find happened and was for, going back to page 12 of the indictment, one of the overlying purposes that the state has alleged, which is important, of preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder. When YSL members were murdered on March 11th, retaliation was needed for the enterprise's reputation and to exact vengeance. And so that overt act alone satisfies. Of course, there is ample overt acts alleged of promoting either the gang itself or violence. I didn't want to run off a litany of admitted exhibits with.
Okay, how about
Yes, Your Honor.
Are you going to talk about what the pattern of interrelated racketeering activity within 4 years of?
So, Your Honor, yes, I will take the testimony that has came out related to YFN Lucci or Mr. Bennett, and that is a perfect example of, you have, when Mr. Sumlin testified and the call was presented of Christian Eppinger, who was in the jail, calling him saying, I'm on PC with that boy Lucci, how much can I get for that? Then you have the text messages that were the color-coded charts that Viverito walked through with Khalif Adams, Demekion Garlington, and Jaden Myrick. Then you have the video that from the jail where Jaden Myrick, after that messages about stabbing YFN Lucci, through the testimony of Viverito of what they were discussing, actively tried to stab YFN Lucci. Then you have the post of defendant Kendrick predating that, but 2019, I believe, standing on top of YFN Lucci's.
All right, but I mean, a post isn't an act of racketeering. So talk about.
Yes, Your Honor. So you have multiple YSL gang members, all of which, I use that example because I believe it's so salient, of multiple actors, multiple ages, multiple years in time. It's the same individual that they're trying to exact violence on, who happens to be the same individual who was very close with Donovan Thomas from 2015. All of those, that pattern, the victim and the method of operation, using other YSL gang members.
All right, so which acts of racketeering activity are interrelated that have to do with that?
Yes, Your Honor. So specifically, you have, let me grab my indictment, Your Honor, so I can see
Sure.
the accurate numbers. Thank you, Mr. Porter. So in terms of overt act numbers, you have Act 171 as the Eppinger and Sumlin conspiracy to commit murder, which was the jail call, which has been introduced. You have overt acts 165 through 167 is Bobby Hunt, Khalif Adams, Demekion Garlington, Scarface, and Jaden Myrick, which is all related to that February 9th, 2022 attempted murder of Mr. Rayshawn Bennett. And you also have, this is not an overt act, but is quite relevant for this purpose, States Exhibit 227 VVB2 is the text message from defendant Stillwell's phone where he says on February 9th at 7:31 p.m., which is, I believe, within 30 minutes of that stabbing, they just wet Lucci's BITCH ASS up, which again shows an us, a them, a concert, an agreement, a pattern, a method of utilizing contacts through jail, prison, or on the streets to concoct a plan and enact violence on a rival gang, specifically a rival gang leader, who, of course, on January 22nd, 2015 and January 26th, 2015, mother's house was shot at 1007 Hill Street. You also have the overt act that is in evidence related to the post from defendant Williams of, if I didn't like what you did for your kids and your mother, I would have been killed you, which was about Mr. Rashawn Bennett, Wyeth, and Lucci. And so all of those things combined, without, you have words in the text messages through somewhat coded language. You have jail calls where Christian Eppinger does mention his name, but you have where they all know what they're talking about, what the goal is. They don't need to go into the agreement and the enterprise's objectives morph into one and the same in terms of without, they don't even, they all have the same common goal of enacting violence on a rival opposition. Is the conspiracy that could be a possibility when I actively join this enterprise is best proven by the attempted murder and the pattern of racketeering proves the conspiracy was alive and well, in this case for upwards of a decade. And all of those, of course, I use because they're more recent. They're well within the 5 years. Your Honor, I also believe that in terms of an overall pattern, when you have of the 28 defendants indicted, there's many connections in terms of Rodelius Ryan was, I believe, 15 when the murder of Jamari Holmes happened. Roughly, the murder happened early that morning around 4 o'clock. Later on that day, he posted a video of, I bet YSL makes the news. He has Instagram messages that are in where he alleges is quite actively stating FUCKYFN, ABG, right? He would have been 11 years old when Donovan Thomas was murdered. When Wooney Lee testifies about, we put that, what on your gravestone, he would have been much younger. He doesn't come up his name in the murder of Donovan Thomas, but the fact that members who either have, actively promoted, tattooed, claim allegiance to this enterprise of different ages, of different times, have the same enemy, the same disagreement through racketeering activity in its truest sense of violence, is the similarity, is certainly for a rational trier of fact to find that there is a clear common interwoven theme, which I use the violence because, again, I believe it's the most salient of this point for purposes of directed verdict.
All right. Can you speak to whether it matters that the indictment itself doesn't contain the language willingly and knowingly, willfully and knowingly?
So, Your Honor, Mr. Floyd was going to address that much more eloquently
Okay,
than I,
That's fine.
if that's all right, but with the court.
Okay. Thank you. I appreciate it.
Yes, Your Honor. Yep.
And you're going to do that for the RICO and the gang counts, the language,
Yes, Your Honor.
Mr. Floyd? Okay.
Okay. Your Honor, first, what was characterized, I think, as a general demur argument, or an argument that included general demur.
Right.
I listened to it and it was very familiar. It was very familiar because it was made and rejected over 2 years ago in the same case. The Ruan case, to which reference was made, is a United States Supreme Court case. It is not a RICO case. It is nothing like a RICO case. It was a case that involved the federal prosecution under the Federal Controlled Substances Act of doctors who had basically signed pill mill prescriptions, and the application of a federal regulation to that circumstance dealing with the validity of those prescriptions. So not on all fours, not on all threes, maybe not even on all twos. The important thing that matters is the statute. First of all, the text of the statute does not make reference to knowingly and willfully. And so the charge is in the language of the statute, which is sufficient. I mean, that's pretty much the end. That's pretty much the end of that argument. To the extent that the argument blurred into kind of a special demurrer argument, the point is that first, it's every defendant is charged with conspiracy. There's no question about who's charged and who's not. It's very clear. It's charged in the language of the statute. Every defendant is alleged to have actually committed acts of racketeering activity. Those require a certain level of intent, and that is proof of the level of intent sufficient to commit a racketeering activity act of racketeering activity has been held sufficient to sustain a RICO conviction by the Georgia courts. They've said there isn't another layer above that. If you have the intent to commit the act and you commit the act, that's sufficient. Page 60, most of this is laid out on page 12, but also of the indictment, but also if you go to page 68, which is at the end of the overt acts, you'll see that we have specifically alleged they were committed in furtherance of the conspiracy, tying every act to that conspiracy, and therefore every individual who committed one of those overt acts to a conspiratorial agreement alleged above that they had the same or similar, which is the test under the statute for relationship. Similar is sufficient. Intents, results, accomplices, victims, or methods of commission, or otherwise were interrelated by distinguishing characteristics. I think Mr. Adkins has well covered that component of it, but it is also specifically alleged here.
Okay, that's page 67 of the.
68.
67 of mine.
Oh, okay,
I-
sorry. You probably have you have the deluxe version. At any rate, it immediately follows the last predicate act. So that'll help us all navigate. The point though is that, and this is as true of the Gang Act as it is of this, the cases that have said knowingly and willfully, or the cases that talk about what has to be proven, are not pleading cases. They're not general demurrer cases. It's just a question of what does the state have to come forward with? Neither statute says knowingly and willfully. Rodriguez is familiar to me. I briefed Rodriguez. Mr. Carlson and I argued Rodriguez. Rodriguez was a facial constitutional challenge. It had nothing to do with the sufficiency of pleadings. And it simply interpreted the statute in light of a vagueness challenge. So not close to being on all fours with this situation. There is no Georgia case of which I am aware that says the state has to allege knowingly and willfully. It's purely a question of proof. That takes us to the directed verdict standard, which is simply, could a rational juror find that these defendants acted knowingly and willfully? Most of the argument on that was simply the defense's interpretation of the meaning and weight of the evidence, which is not a permissible consideration in this analysis. The court cannot resolve those issues. And for a case that's directly on point on that is the Evans case, which I believe I cited to you yesterday. It's the other APS appeal along with Cotman, and it lays out the standard in the specific context of a directed verdict or motion in a RICO conspiracy case. And the standard that it enunciates is exactly the same
I didn't
as.
think you cited that yesterday. Can you give
Okay,
me
I'm
that?
sorry. It's Evans v. State. By recollection, it's a 2019 decision. I don't have it immediately in front of me, but there's only going to be one Evans RICO APS. There it is. It is 360 Georgia Appeals 596 at 600. The court said the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And thank you. And just since I'm up, the question of, I guess I'd call it the more than one overt act being alleged, more than the jury seeing more than one overt act. I mean, the logic behind that is kind of topsy-turvy. If you think about it, there's nothing that requires the state to plead the barest minimum in an indictment. And in fact, generally to do so, we would draw a wave of special demurs. Even with this indictment, we drew special demurs with as much detail as it has.
At this point, they're not any longer challenging what you put in the indictment. They're saying whether it's in there or not, it shouldn't be out with the jury for their consideration.
Well, that comes down to if I understand correctly, an argument that there's not sufficient evidence for the jury to find the defendants acted knowingly and willfully, and that is clearly present.
Oh, no. I think we're interweaving
I'm sorry,
different
then,
issues now. I thought you were moving on to the issue of whether overt acts that aren't within the 5 years,
and
whether it
indeed, I
yes,
am.
it was definitely okay to put them in the indictment, whether they should go out with the
Yeah,
jury.
okay, I understand.
If you weren't, then bring me back to what.
No,
we
I may
were
have,
talking
I may
about.
have ground the gears a little bit on that
Okay.
one. But I think I just want to make sure you don't have any more questions about the knowingly and willfully issue. And if you don't, then I'll move on to that question.
Okay.
If I understand the logic chain from the defense, it is basically, we only have to prove one overt act within 5 years of the day of the indictment. Therefore, anything else is, I think the term was used, surplusage. That doesn't fit the definition of surplusage. And then with particular emphasis, they've said if it's outside of that 5-year window and then would not be relevant to prove the timeliness of the indictment, that then particularly the jury shouldn't hear it because it's confusing, et cetera. I'm aware of no case that has accepted that argument. And it shouldn't be accepted because the allegations are relevant. They show the existence of the enterprise, right? This begins, it begins a long time ago. The state is not precluded from charging or presenting evidence that shows this enterprise has existed for a long time. I mean, at the kind of the extreme level of this, there are federal RICO indictments involving the 5 families in New York that discuss the entire history and formation of them, going back to the Castle Amorisi War of 1932, I think it is. So they would now span almost a century. That was not irrelevant because it tells you how this enterprise came to be, and it shows the early participation of certain individuals. It shows its longevity, its consistency. I mean, under the law, enterprises don't have to be in operation 24 hours a day. They can have lulls, et cetera. But where they continue to exist, where the people who participate in them continue to acknowledge their existence, that is certainly relevant. And there's not an arbitrary cutoff where the indictment gets trimmed to match the statute of limitations. I'm just not personally aware of any case that's ever done that.
Okay.
Thank you.
May I respond briefly?
Well, I mean, we're still in the middle of the state's presentation, so yes, y'all both get it, since it's your motion, a chance to reply, but not right now.
Good morning, Your Honor. I'll be addressing the directed verdicts as to counts 2 and 49 of the indictment, which are the murder counts. Count 50, 51, and 57, which are the participation in criminal street gang activity. counts, Mr. Floyd, whenever the court's pleasure, will address the general demur as to the participation in criminal street gang activity.
I mean, Mr. Floyd, did you have anything, I mean, I took your argument to be essentially, the knowingly and willfully as it applies to RICO, and then basically apply the same argument with regard to the in furtherance of the gang, with regard to the gang counts. Did you
Yes,
have
ma'am.
anything to add to that?
Not really, Your Honor. The statutes are quite similar on this point. Historically, the Gang Act is actually kind of a linear descendant of RICO, that some states didn't want to enact a full RICO. They just enacted the gang statute. We enacted both. They have slightly different elements, but on this principle, there's really no difference.
Thank you.
Thank you.
And then I'll be addressing count 62, possession of a machine gun. And then count 52, 64, and 63, which are the possession of firearms by a convicted felon.
All right, 52 isn't the 133, right?
No, Your Honor. 133 will be count
63 and 64.
63 and 64, Your Honor. So, Your Honor, as Mr. Floyd just enumerated, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt, and that's cited in Evans v. State, 360 Georgia Appeals 596, which is a 2021 decision. And first, we're going to start with count 2, the murder of Donovan Thomas Jr., Your Honor. The state has presented evidence that we believe will be sufficient for a rational trier of fact to review in the light most favorable to the prosecution. Your Honor, we have presented evidence of the June 10th, 2015 video recorded interview of Mr. Kenneth Copeland at the Atlanta Police Department, which is Exhibit 378, Yankee Echo. In that video, Your Honor, Mr. Copeland discusses a co-conspirator statement of Deamonte Garlington, in which Deamonte Garlington tells him about the murder of Donovan Thomas, that who was involved, which was Mr. Stillwell, Mr. Kendrick, Mr. Justin Cobb, Mr. Damas, and Mr. Damas McMullen. In that interview, Mr. Copeland speaks of his whereabouts on the day of the murder of Donovan Thomas, beginning on early in the morning hours, and when he eventually meets up with Mr. Garlington at a gas station on Cleveland Avenue. He further tells the detectives that Mr. Garlington told him that those 4 individuals, again, Mr. Stillwell, Mr. Kendrick, Mr. Cobb, and Mr. McMullen, had committed the homicide of Donovan Thomas Jr. He told them about the type of car that they were in, which was an Infiniti vehicle, the location of where Mr. Donovan Thomas was, which was the barbershop on 330 McDaniel Street. We then also introduced the August 2015 statement of Quindarius Zachary, which was State's Exhibit 531Y, which Mr. Zachary corroborated some of the same information that Kenneth Copeland provided. He also added the additional information or evidence in that interview, which was Mr. Stillwell and Mr. Kendrick at the condo of Jeffery Williams confessed to him that they had participated in the murder of Donovan Thomas Jr. Those statements and the detail of those statements are corroborated by certain other evidence that has been admitted. We have the barbershop surveillance video, which is at 292 Yankee Alpha through 292 Yankee Delta. That video surveillance showed Mr. Donovan Thomas Jr. outside the barbershop moments before a silver and color vehicle, which was identified in testimony as an Infiniti, drove down the street and shot several rounds of gunfire at and towards the direction of Mr. Donovan Thomas Jr. We also have the Texaco surveillance video, which corroborated Mr. Kenneth Copeland's statement. In his statement, Mr. Copeland tells officers that Deamonte Garlington told him that they met at the Texaco gas station, that they switched cars, which he explained that Mr. Kendrick initially arrived in a Pontiac Bonneville, and that the gray Infinity vehicle met at the Texaco gas station. That was depicted on the surveillance video. In the surveillance video, you see Mr. Kendrick walk into the gas station. You see Mr. Kendrick approach a silver Infinity vehicle. You see both of those vehicles leave out of that gas station at the same time. Your Honor, yes, what we do not see is when the transition occurred between Mr. Kendrick getting out of the Bonneville and getting into the Infinity, but we believe there's a reasonable inference that that happened off camera outside of, we believe, behind the Texaco gas station. Mr. Copeland also discussed in that interview that the car that they used was rented by Mr. Jeffery Williams. We were able to admit State's Exhibit 334Y, which was the rental agreement from Hertz Rental, which showed that the vehicle was rented by Mr. Williams about 2 days before the homicide of Mr. Donovan Thomas Jr. We then also have phone records that corroborated what Mr. Copeland said. We have the phone records that show that when Mr. Copeland woke up in the morning hours, or the afternoon hours, excuse me, of January 10th, 2015, he was located. He told police he was at his girlfriend's home, which was in the village of Carver Homes. The phone records corroborated that his phone was at that location at that time. He then proceeded to tell officers that from leaving his girlfriend's house, he went to the Green store. The phone records corroborated him going to the Green store. The phone records then corroborated what he told police, that he then went to the McDonald's gas station, the McDonald's restaurant, and that's where he met with Deamonte Garlington, and that's when Deamonte Garlington explained to him everything that occurred. Mr. Copeland was also able to tell the police that Mr. Demise McMullen actually was at the McDonald's when he arrived, or when he met with Mr. Garlington. The phone records corroborate that Mr. McMullen actually made contact with Mr. Williams about 6 minutes after the murder of Donovan Thomas. Immediately following the phone call with Mr. McMullen, there is a number of different phone calls to a variety of different people, specifically an individual by the name of Kelvin Treadwell, OG Bentley. Both Mr. Copeland and Mr. Zachary, in their statements, advised that after the murder of Donovan Thomas, that the guns in the vehicle were given to Kelvin Treadwell, also known as OG Bentley. The phone records corroborate that a number of different phones, Mr. Williams' phone, Mr. McMullen's phone, all ping in the location in and around near Kelvin Treadwell's home after the murder. Their phones ping off of the tower closest to Mr. Treadwell's home. So that evidence has come in, Your Honor. We have the autopsy photos that show that Mr. Donovan Thomas was murdered and killed with certain types of shell casings. Your Honor, we have the jail call of Mr. Stillwell. I do not have that exhibit number, which was entered after his preliminary hearing, Your Honor, in which at the preliminary hearing, we know from both Investigator Thorpe and Deputy District Attorney Michael Sprinkle that during the preliminary hearing itself, they didn't use any names. They used witness number 1, witness number 2. However, on the jail calls that we have both with Antonio Sledge and Mr. Stillwell, that they identify one of the witnesses being Little D. Little D was the nickname for Quindarius Zachary. And what Mr. Stillwell said during that call is, they snitched on me. And I'm paraphrasing. It was never, they lied on me. There was never any other language, but we have that evidence. We have that in evidence. We also have in evidence, Your Honor, State's Exhibit 477NN, which is the Slat Talk video, in which Mr. Stillwell says the words, "I just beat a murder rap, pay my lawyer $30 for that." Also, he has we introduced more recently another song that Mr. Stillwell has, which was called BS or Bullshit. And in that song, he says, beat the harm, no evidence. We believe that that is another reference to the murder of Donovan Thomas. We also have State's Exhibit 436 VV, which is Mr. Stillwell after in 2019 posting a picture with himself in a slime sweatshirt with the peanut gravestone in Spanish, then immediately deleting that from that Instagram post within a few minutes after posting it, Your Honor. So we believe that there is sufficient evidence for the jury for a rational trier of fact to be able to find the essential elements of the crime beyond a reasonable doubt. Next, Your Honor, I will go to count 49, the other murder count in this indictment, Your Honor. Your Honor, the state has admitted crime scene photos of the crime scene at the time. That's going to be State's Exhibit 65, Victor through 115, Victor, specifically 79, Victor has Mr. Shamel Drinks deceased inside of the
We
car.
definitely know he's dead.
Yes, inside of the car. We then have, Your Honor, the surveillance videos from, specifically, I'm going to focus on the BP surveillance video, which is State's Exhibit 116 BV, and the FedEx surveillance video, which is State's Exhibit 117 BV. In both those videos, Your Honor, initially, before we know who is identified, we see a white, extremely darkly tinted Audi vehicle come to the gas station. We also see a white Ford Fusion. We see individuals from those two vehicles enter into the gas station. We later learn that that is both Shannon Stillwell, Quarmavius Nichols, and Miles Farley. We have the evidence that in that same surveillance video, within 5 to 7 minutes after they are at the location, Mr. Drinks arrives at their location in his red vehicle. He is seen walking inside of the store. That surveillance video then shows that when Mr. Drinks' red vehicle leaves, very soon thereafter, both the white Audi that's tinted leaves the location, as well as the white Ford Fusion. We do have a wiretap telephone call, which is State's Exhibit 437 VV. The call, I can't recall the page number at this time, Your Honor, but the call that is at 9:59 p.m. based upon the wiretap data, which is a call that tells from Deamonte Garlington telling another occupant of the white Ford Fusion to immediately get on FaceTime, Your Honor. There's evidence from even Mr. Deamonte Garlington's wiretap where they talk about getting on FaceTime when they don't want to discuss certain things on the phone. We also heard that from expert witnesses that FaceTime is a mechanism that is used when criminal activity is going to take a foot because it cannot be tracked. At 9:59, that call takes place. We then see on the FedEx surveillance video at approximately 10:01 p.m., Mr. Drinks arrives at the lights, as well as the white Audi, as well as the white Ford Fusion. The white Audi and the Ford Fusion stay at the light for approximately 2 minutes, Your Honor, before they take off into traffic, running the red lights. Your Honor, at that time, the red vehicle never moves again. We see from the ankle monitor records, Your Honor, based on the evidence that was provided in the ankle monitor records, that within a minute, Mr. Stillwell's ankle monitor goes from 18 miles per hour to 90 miles per hour. We know from the phone records that both cars travel in the same direction towards Fulton Industrial Boulevard, where we believe they go to a music studio. We then have from Mr. Stillwell's phone a phone note in which, I'll paraphrase, he talks about dropping the ops. Very soon thereafter, and that is right after Mr. Drinks is at that light. We then have, Your Honor, again, phone records that put both Mr. Stillwell, Mr. Farley, Mr. Nichols all in the same area, which is the area of the gas station in and around the same time. Your Honor, we have social media posts. Oftentimes we don't have motive, but we have social media posts in this case that were posted between March 11th, 2022 and March 15th, 2022. One, we know that on March 11th, 2022, the evidence showed that two YSL associates were murdered on a highway, both Mr. Christian McMiller and Mr. Darius Ford. And we have in evidence Stacy Exhibit 452 VV, which is a post from Mr. Stillwell. And I believe this post is on March 11th or maybe March 12th that says, "Just rest, Mac, I got you." Then we also have a post, which is 458 VV, that is posted on March 11th with Mr. Stillwell posting, "I ain't gonna be the only one crying." Then on March 15th, 2022, we have Scarface, who is, we believe, in the car with Mr. Stillwell at the time that the murder takes place, posting a picture of both Mr. McMiller and Mr. Ford saying, "We got y'all boys." And that is only hours after the death and murder of Mr. Shamel Drinks. We then also introduced, Your Honor, the rental car agreement, which showed that Mr. Stillwell rented this vehicle on March 14th, 2022. And then we also have the wiretap information that shows that he went to a tinted window car place and got deep tinted tints on this car on the day that this occurs, Your Honor. And then we have text messages while in January of 2022 saying that he goes op hunting. So, Your Honor, we believe that that evidence is, that evidence is evidence that a rational trier of fact could find the essential elements of the crime of murder beyond a reasonable doubt. Next, Your Honor, I will go to count 50 and 51, which are both the participation in criminal street gang activity as to Mr. Shannon Stillwell, and then count 57 as to Mr. Deamonte Kendrick. Mr. Atkins touched on this somewhat, but I'll just add some additional evidence that has been presented. We have the testimony from investigator Mark Belknap, Trontavia Stevens, Walter Murphy, Antonio Sledge. Well, sometimes it was easy to get out, sometimes it wasn't, but they all have said that YSL is a gang. We have evidence of the tattoos of Mr. Kendrick, which was 518 VV to 520 VV, which—
Before you do the gang counts, can
Yes.
you address the 58 through 61 drugs and machine gun, and whether there's evidence of constructive possession for Mr. Kendrick?
Yes, Your Honor. So first with the possession of machine gun, which is count
62, yes, sorry.
One, just the proof that of the gun itself, we have the—
I know that that's established.
Okay, so as regarding Mr. Kendrick, Your Honor, there is evidence that we know from his phone that he had been at the home earlier that day. We know that based on testimony from Officer Samba, that he fled from the home
No, he was, okay.
and apprehended, Your Honor, and we believe that that would be some evidence of consciousness of guilt, the fact that he fled before the police even, I think, hit the door of the home, that he had fled out of the home, Your Honor. We believe that inside of the home, there were a number of guns, both from the pictures, you can see that there's a number of guns outside on the kitchen table. There were some guns.
Remind me where the machine gun was found?
The machine gun is actually downstairs, we believe, in the basement of the home by, underneath
Laying
the
on the
couch.
floor?
Yes, laying on
Yeah,
the floor
okay.
underneath the couch, Your Honor. It is the state's theory, Your Honor, that when the SWAT team did not make a quiet announcement to get to come into the home, and it is the state's theory that when the announcement was made, you could tell from some of the images, we believe that there was an effort to hide some of the items that were inside of the home. This gun was kind of maybe kicked underneath the couch where you had to pull the, it looks like they pulled the couch back in order to observe this gun that was actually in the basement, Your Honor. To address the drugs, Your Honor, which are counts 58 through 60, which is the possession of marijuana with intent to distribute, the possession of codeine, and the possession of cocaine, Your Honor. I believe all of these items, which was Stacy Exhibit 12XX, 17XX, and 18XX, the marijuana, I believe, was out in the open. My memory serves me correct, I need to pull up the picture again, but I believe that the marijuana was out present and open in the home, Your Honor. That specifically 18XX was not hidden. 17XX was the marijuana with guns that was found in a cabinet, I believe above the refrigerator inside of the kitchen of the home. And then the codeine, if you give me a moment, I just want to pull up the picture so I can make sure I know where the codeine was found
They
inside.
were like
of-
in a box in a closet, right?
I believe they were, but I thought that there was some that was out as well. But of course, indulgence. Yes, Your Honor, the codeine was found in the closet and then in the bathroom upstairs in the house. And then the cocaine was found in the pantry as well. In that same bag, there was a bag that had in the pantry that had the cocaine and the cocaine and the codeine, Your Honor.
And the marijuana was out where, in the kitchen?
So there's one in a Tupperware container that's in the, on the kitchen counter, and then there's the bag of marijuana that was in that cabinet with the gun
Right.
that's in the cabinet above the, I think, the refrigerator.
Was there any evidence presented that Mr. Kendrick was like staying there as a residence, or just that he was there that day?
No, Your Honor, the evidence that we have is that he was present that day, and we believe that he had been present maybe a few days before.
But not continuously?
Not continuously, no, Your Honor.
And so can you address constructive possession?
Your Honor, it's just the state's position that at the time of Mr. Kendrick being at the home, that he had knowledge of the drugs being present in the home, Your Honor. Specifically the marijuana, Your Honor, as well as the guns being in and around the home.
He's only charged with a machine gun, right?
He's charged with a machine gun, and he's charged with possession of a firearm during a commission of felony with all the other guns that were found inside of the home, Your Honor. So he's charged
That's
both.
the count.
That's-
Which count is that?
Yes, Your Honor.
That's count 63.
Yeah, so count 62 is a machine gun, and count 63 is possession of firearm by convicted felon for the other, in addition to the machine gun, the other guns found inside.
Where are
of
all
the
of
home.
those found? Remind me if you don't mind.
Yeah, they're found in different locations. So I believe the FNH 57. I don't- So 13XX, Your Honor, the FNH 57, and that's found on the kitchen counter behind like a green dinosaur. And then there's the two firearms.
Can
which
you
is-
show me a picture of that? Let me join Zoom. Yeah, I am too.
So Your Honor, this is, I believe the FNH 557, and that's in the living room area.
All right, those are just sitting out on the counter, right?
Yes.
All right,
And then
that's in the cabinet.
that's
That's
two-
above, yeah.
Yes, Your Honor,
So a lot of this looks like it's documenting what the guns are. I just want to see the ones that show where they were found.
so these are two more.
Those are in the cabinet.
Those are in the
up
cabinet.
above, yeah.
This is the pantry, Your Honor, where this other gun was found.
That's like I think somebody referred to it as like the hidden
Yes. It's
door or something like that.
Yes, Your Honor.
And that's where the codeine's found too?
Yes, Your Honor.
Mhm. And the cocaine?
Yes.
Okay.
And then this is where the machine gun is found, Your Honor.
That's after the couch is moved or after it's,
Yes.
any idea where, do we have a picture of the couch before it was moved?
No, I don't think so, Your Honor. I think once they moved it and found it, they took a picture of it.
Okay. All right, thanks. All right, and then you were gonna circle back to,
Your Honor, I guess there's one more gun to be shown.
okay.
And there's one found in the upstairs bedroom.
Whose bedroom is that?
We believe this is, the room. We think that the ID for Jimmy Winfrey was found in this room.
For who?
Jimmy Winfrey was found
Okay.
in this room.
All right.
Go back to the gang count, Your Honor?
Yes.
Okay.
And address Mr. Kendrick's count first, which is 57.
Your Honor, it's the state's position, Your Honor, that the drugs inside of the home were all specifically the possession, the codeine, Your Honor, as well as the marijuana with the phone counters were being prepared for distribution. If you remember, there was the large pail of codeine that was found, a number of different bottles being found, Your Honor. As you also saw, although not charged because it's not illegal, was the YSL drink juice that was inside of the home, Your Honor, which looked like that was being packaged for some type of sale or distribution of itself, Your Honor, that these particular drugs were possessed in furtherance of the criminal street gang to sell narcotics, Your Honor, to sell both marijuana as well as to sell the codeine. We have evidence of the money counter inside of the home, Your Honor. Mr. Kendrick was at the home, was present at the home. There are a number of different guns present inside of the home, which we know guns are usually kept with drugs in the sale of drugs, Your Honor. And so based on that evidence, we believe that there's sufficient evidence to go back to the jury to show, at least for that count, participation in criminal street gang activity, given that evidence that has been admitted into evidence, Your Honor.
We didn't have any evidence as to like the weight of the cocaine or anything like that, did we?
Yes, I believe the GBI did.
Okay, maybe y'all just didn't highlight that.
Yes,
But that wasn't a.
that's not an intent
That
to
wasn't a
distribute. Yeah.
distribution
No,
amount.
no,
Okay,
that's
right.
simple
All right.
possession. And Your Honor, it's specifically regarding the guns, because we also charged count 57 with the guns. The state believes that they were still in the midst of a gang war. This was only 2 months after both Mr. McMiller and Mr. Ford had been murdered. There had now been the retaliatory shooting of Mr. Shamel Drinks. We know that 2830 Waters Road had been shot at multiple times. And so we are now still in the midst of, or we believe, a gang war. And with that amount of guns and weapons inside of the home, a machine gun, Your Honor, that these were tools, whether it was to protect themselves or get ready to go and continue war, that they had this ample amount of firearms inside of the home, all in furtherance of this gang war that we believe is still going on even to this day, Your Honor.
All right, moving on to Mr. Stillwell's other counts.
Yes, I believe Mr. Stillwell's count that I have not addressed yet are participation in gang activity, which I believe
Oh,
Mr.
yeah, save that one to last. Let's talk about the underlying ones first,
Okay.
if you don't mind.
So I believe his next count is possession of a firearm by a convicted felon and possession of a firearm during the commission of a felony, Your Honor. I believe those are the last two.
Okay, hang on then. So.
And I will address the possession of a firearm during the commission of a felony, and then Mr. Abati will address the 133 possession of a firearm by a convicted felon.
Give me a second. I'm sorry, they're kind of not all together in the indictment. I
No
wanna make
problem,
sure
Your Honor.
of. All right. Go ahead.
Okay, so for count 54, Your Honor, possession of a firearm during the commission of a felony, Mr. Drinks was killed with, I believe, a 40 caliber, I believe, a Glock handgun based upon the GBI testimony that came in. Your Honor, there was testimony yesterday from Investigator Viverito that in a video that's was created about an hour before the murder of Donovan Thomas, that there is a gun that could be consistent with a Glock 27, which is a 40 caliber handgun. That is the evidence that we have, Your Honor. We never recovered the handgun used in this case, Your Honor, but there is evidence. I believe if we look back to the Donovan Thomas murder, that after that murder, they got rid of the gun. It's the state's theory that the same thing occurred in this case, that after the murder of Mr. Drinks, that they did get rid of the Glock handgun that murdered Mr. Thomas. But we do know that he was, Mr. Drinks, but we do know he was killed. It is the state's theory that Mr. Stillwell shot and killed him, and would have shot and killed him with a 40 caliber handgun, Your Honor.
All right, and then the other gun one was the one that was tossed or that.
Yes, Your Honor, and then we
tossed
know from Miss,
right before they were arrested.
right before that, I'm sorry, that's count 60,
Okay, that was registered to.
Miss Taisha Alexander, Your Honor.
All right.
And I do believe for the gang, Your Honor, Mr. Adkins discussed that within the RICO when he talked about
Okay.
the gang. So
Thank you.
thank you, Your Honor.
All right. Reply argument.
I don't feel the need to go on and on, but Your
Mhm.
Honor, I just wanted to clarify one thing. I felt that there was kind of a straw man where my argument was being presented about the overt acts alleged, that I didn't, the state needs to give a history, and the jury needs to hear about the history of different acts. I'm not saying that those overt acts aren't relevant. And obviously, we've been in here for a year. They've presented evidence of those overt acts, many of them, not all of them. My assertion and my argument is merely that the state should not be allowed to create an indictment with alleged overt acts that are outside the statute of limitations, and then a listing of those overt acts goes back to the jury as part of the indictment. And that's all I'm arguing with that. Not that it's irrelevant, not that they can't get into it, because
Yeah,
obviously they
I
have.
understood that to be your argument. I appreciate that. Thank you.
Your Honor, the state stood up here and gave a very thorough response to our motion for a directed verdict. But they never once, and I was listening very carefully, and you specifically asked them about the constructive possession. They never once made argument regarding any intent shown by Mr. Kendrick on possession of those drugs or guns. They made some arguments perhaps about ability, although even that I think was somewhat strained, where you have firearms that are in cabinets and closets and wherever, and he's just a guest in the home. The issue of intent is one, again, that you're going to instruct the jury on in the jury instructions. You also have a mere presence that you're going to instruct the jury on. So Mr. Kendrick, while he may have been present in the home, there hasn't been any evidence regarding intent, Your Honor.
All right, why don't we take, I don't know if lunch is here yet, but why don't we take a break for a little while? Y'all can see if you can get together and come to whatever agreement you're going to come to on overt acts that there hasn't been evidence presented on. And I want to read the motion that got filed and look at some of the case law and maybe review some of the evidence. And then presuming I don't grant the motion on every count, which I think maybe there's been some acknowledgement that at least a tiny bit of one count might be able to go forward. We need to finish the charge conference. You were going to say something, Mr. Sharp?
I was just going to let Your Honor know that I did, calling it a chart is really giving it way too much credit. But I did email that to Ms. Persfield and the state, and I will update it after I confer with the state and
that's
figure out.
I didn't mean to oversell what we had put together last night.
It's fine.
One other thing, as far as the charge conference goes, I did submit one additional proposed jury instruction to
I
Ms.
saw that
Percival.
one. I'll be interested to hear your argument on that
Thank you.
and the state's response.
Yes, Your Honor. And on that note, we have discussed the charges for the overt acts
Mhm.
that the jury would not otherwise be instructed on, like armed robbery. I just want to let the court and defense know that the state has and is about to submit
Okay.
to the court parties the underlying crimes of the
Okay.
overt acts that are crimes and not otherwise alleged.
All right, thank you.
And, Your Honor, when it's appropriate, it can be later but could the lawyers from each side approach about a scheduling matter?
Y'all can do that now. And I'll give y'all my ruling on the motion for directed verdicts, motions for directed verdict, and we can do whatever else needs to be done with regard to the charge conference. However, I guess on the do y'all mind doing the overt act thing and then getting that to me and then going to lunch so that I can have that with me? Okay, thank y'all.